What does it mean to settle an estate? When a person passes away, their assets must be distributed to their family, heirs, or beneficiaries according to the person's will or trust. If they don't have a will or trust, the state probate code, as enforced by the county probate court, will dictate how those assets are going to be distributed or how the estate should be settled. Settling an estate includes the following steps. First, get appointed as administrator or personal representative of the estate. Second, identify, record, and gather all the decedent's assets. Third, pay the decedent's outstanding debts and taxes. Fourth, distribute the remaining assets to family, heirs, or beneficiaries. Fifth, terminate or close the estate. Next topic, how do I settle an estate? If you are the administrator of an intestate estate, an estate without a will, or an executor of an estate, which is an estate with a will, you can settle the estate yourself by following the probate code, if no will, or the decedent's directives contained in a will, if there's a will, while going through the probate process as prescribed by the state probate code as administered in the decedent's county probate court. If you are the trustee of the decedent's trust, you most likely will be able to administer or settle the trust without court intervention at all, as long as you follow the decedent's directives as set forth in the trust, regardless of whether you are the administrator of an intestate estate, again no will, executor of a will, or trustee of a trust. A probate attorney is a vital resource to ensure the administration is completed properly, timely, and while avoiding unnecessary costs and delay. How do you settle an estate without a will? If there's no will and you want to administer your loved one's estate, you should hire a probate lawyer to help you navigate the California Probate Code and the county probate court processes. Here are the general steps. First, get a copy of the decedent's death certificate. Second, file a petition for probate in the county probate court where the decedent lived. Third, attend your probate hearing. Fourth, once your petition for probate is granted, obtain letters of administration from the court, which are the documents that actually authorize you to act on behalf of the estate. Fifth, identify, record, and gather all the decedent's assets. Sixth, pay the decedent's outstanding debts and taxes. Seventh, account to the court, essentially tell the court what happened during your administration, and seek from the court an order for final distribution, allowing you to close the estate. Eighth, as per the order you get from the court, you'll pay yourself as administrator of the estate and your probate attorney as well. Ninth, you'll distribute the remaining assets as per the court order to the family, heirs, beneficiaries, etc. 10th, you close the estate. You're done. Next topic, is it more difficult to settle an estate without a will? Generally, it can be more straightforward to settle an estate without a will because the California State Probate Code is unequivocating as to how assets are going to be distributed. There's no dispute because there's no will. However, when there is no will to dictate how specific assets should be distributed, some extra steps may be required. For example, if the decedent owned a real estate property, a house, a condo, and is survived by multiple children or multiple siblings, multiple parents, who don't want to share ownership of the property, then that property likely will need to be sold and the proceeds shared amongst those heirs as prescribed by the probate code. If the decedent had a will, the will might dictate exactly how that asset is to be distributed. How long does it take to settle an estate by myself? If you're settling an estate by yourself for the first time and there's no will, it can take as few as 12, but often as many as 36 months to settle an estate, depending on the size and complexity of the estate, its assets, number of creditors, etc. Smaller estates may be settled even faster. As the value of the estate increases, the time frame will vary based on any number of factors, including 1, perhaps there are multiple real estate properties, homes, vacation homes, condos, etc. 2, business interests. 3, high-value personal assets that might need to be sold at auction, for example. 4, surviving spouses. 5, surviving ex-spouses. 6, surviving children, stepchildren, adopted children. 7, extensive debts that will need to be paid, negotiated. 8, taxes that again will need to be paid. Those often cannot be negotiated, as you might expect. And 9, creditor claims. Next topic, can I settle an estate faster with a probate lawyer? The reality is yes. If you're working with an experienced probate lawyer, the average time to settle an estate should be somewhere between 9 on the short side to 24 months on the outside often even shorter than the 24 months. Again, depending on the size of the estate. And some smaller estates can be settled even faster. Next topic, can you settle an estate without probate? If the decedent created a trust and funded all the assets into the trust, then probate can be avoided. Or if the value of the estate is under $150,000 and the estate does not own real property like a house or condo, then probate again can be avoided through the use of a small estate affidavit. Next topic, how long does an executor have to settle an estate? It depends. The courts try to help move cases along. Probate is no exception. That being said, the courts are not there to, and judges will not provide legal advice. If you are an administrator or executor who's having problems, or if you're a beneficiary or heir of an estate that's stuck, contact counsel. We have successfully unstuck many probates, wrapped up administrations, and got beneficiaries and heirs their inheritances sooner. How long should I keep records after an estate is settled? A general rule of thumb is that you should keep the settled estate documents for 7 years after the estate is settled, largely for tax reasons. Next topic, what are the average legal fees for settling an estate? If you're settling an estate by yourself, there are no attorney's fees, only administrator fees, which generally are set by statute. Costs too generally are standardized and quite minimal. Plus, as the executor or administrator, you eventually should be able to reimburse yourself for any costs you paid out of pocket from the estate assets as approved by the court. It's highly recommended that as an executor you set up an estate account that you fund with the estate assets, from which you may be able to pay a portion of the ongoing probate costs. Here are a few costs you should expect to pay. 1. The cost to file the petition for probate, which can be somewhere between $300 to roughly $500. 2. Probate court documentation fees, which can run in the ballpark of $50 to $100. 3. The cost to set up an estate account with a bank or financial institution. Those fees vary. It could be $0, it could be a couple $100. And 4. The cost to close the estate, which can be $300, $400, $500. Next topic, what does a lawyer get paid for settling an estate? Probate lawyers are paid by and from the estate, so they cost you individually nothing out of pocket. Plus, ordinary probate lawyer fees are standardized by statute based on the value of the estate. It's a flat fee, and additional fees generally are rare, although they can happen if you're selling a business, running a business, selling a piece of real property, etc. Probate lawyer costs generally are the same as what the executor of the estate is entitled to pay themselves under the statute for those ordinary fees. So if you're an executor or administrator and you hire counsel, the attorney can utilize his or her experience to expedite the process for you for the same small fee you can charge, or you can waive your fee if you're also a beneficiary or heir. Do I need a lawyer to settle an estate without a will? No. However, as the value of the estate exceeds $500,000, it becomes prudent to work with a probate lawyer, if only to reduce the risk of mistake in future litigation. For example, if an experienced probate lawyer is more likely to follow probate code procedures more accurately, which limits the ability of other individuals to sue the estate, as well as avoids delay and potential litigation over those delays. As the value of the estate increases beyond $1 million, lawyer fees become rounding errors, largely nominal. And in the case of very high value estates, say over $5 million, working with a probate attorney is critical, as these more sophisticated, higher value estates almost always come with wrinkles a layman may not identify. Next topic, when should I contact an estate attorney? Contact an estate attorney or probate attorney as soon as you can after the death of a loved one. The estate attorney or probate lawyer will help you do everything from locating the will to filing the petition for probate, setting up the estate account, identifying and gathering assets, identifying heirs and beneficiaries, negotiating and paying debts, accounting, distributing assets, and closing the probate. And remember, they work based on a standardized statutory fee, which is paid by the estate. So it should cost you effectively nothing. Do I need an estate attorney near me? We recommend finding an experienced estate attorney or probate lawyer familiar with the county probate court in the county where the decedent passed and where the estate's going to be administered. For example, if the decedent lived in Los Angeles, we recommend working with an estate attorney or probate lawyer in Los Angeles. That Los Angeles probate lawyer generally will be more familiar with the Los Angeles probate court than an out-of-state or out-of-area attorney. If you have questions, please feel free to reach out, call or email us. The consultation's always free. Thanks for watching.